SJC-12108, Odin Anderson and others, v. National Union Fire Insurance Company of Pittsburgh and another.
Not yours either, huh? Is this yours?
Thank you. Good morning, Ms. Sullivan. You back from California?
Yes, Your Honor.
Welcome back.
Good morning, Your Honor, and may it please the Court. My name is Kathleen Sullivan, and I represent the insurers in this case, National Union and the two AIG entities. The issue before the Court is strictly a matter of statutory construction within this Court's de novo review. The sole question before you is whether, in a 93A action, in which the damages result from willful conduct, and in which the damages are based on doubling or trebling an underlying judgment, should post-judgment interest on the underlying judgment be included in the judgment that is multiplied? And the answer to that question is clearly no, it should not. And to begin where we always begin in a case of statutory construction, we begin with the text of the statute itself. Chapter 93A, Section 9 provides that in a case of willful conduct where we're multiplying the judgment, where we're determining actual damages is defined in Section 9 as the amount of the judgment on the underlying claim.
Does that include attorney's fees?
It depends on whether they're included in the judgment. They were not in this case. If they're included in the judgment, anything included in the underlying judgment is included. Okay. So if costs and attorney's fees are included, they're multiplied. Here there were costs, they were not multiplied. Okay. But the key thing, Your Honor, is that post-judgment interest is never part of the underlying judgment.
Almost by definition is what you're saying?
By definition, Your Honor. And how do we know that? Because we have to harmonize 93A Section 9 with the rest of the statutes applicable to interest. And if we look at the pre-judgment and post-judgment interest statutes, we know that post-judgment interest, unlike pre-judgment interest, is never part of the underlying judgment. So, Your Honors, we have these for you in the addendum to our brief, but just to recap briefly, the pre-judgment interest statute, Chapter 231, Section 6B. So the ordinary statute applicable to prejudgment interest in a tort action.
But it goes totally contrary to what the purpose of the punitive damages are, doesn't it? I mean, it rewards you for taking as long as you please to pay that judgment that you should have paid years and years ago.
It absolutely does not, Your Honor. It does not reward in any sense. But let me just go directly to that, and then we'll go back to the statutes. So the purpose is to punish, and the punishment comes from multiplying the judgment. And here the judgment multiplied provides all the deterrence you need for both pre-judgment and post-judgment conduct. Your Honor, if we win this case, and you agree that post-judgment interest is excluded, the lower court will have already imposed 3 times the underlying judgment. And that's the deterrent, Justice Botsford. That's the deterrent. The deterrent here, if you want to look at my learned friend's brief in Addendum 14, you'll see that the trial court took the post-judgment conduct, the conduct of taking the appeal, and the judge said, this post-judgment conduct is part of why I am trebling the underlying judgment here. The deterrence comes from the trebling. As Your Honor noted in Rhodes, this can lead you to stratospheric numbers. And let me just recap the numbers here. If we win, the trebled underlying judgment in the underlying case is going to yield $6.7 million. There's going to be post-judgment interest on that amount from the 93A action of $1.6 million, and then there's going to be attorney's fees in the 93A action, plus interest on that. So there's going to be a $10.1 million 93A judgment if we win. All I'm arguing to you here is that you don't also tack on the post-judgment interest on the judgment below.
How do you get prompt payment then?
Well, Your Honor, first of all, payment is completely protected. There's post-judgment interest, single post-judgment interest on the underlying verdict. That amounted here to $1.4 million. So that, the time value of money is compensated. The
And
deterrent,
when you're talking about post-judgment interest, you mean from the time of the jury verdict to the time that it was paid? What are you talking about?
so Your Honor, what I'm arguing in this case is that post-judgment interest from the judgment may be.
From Judge Davis's judgment?
Judge Davis's judgment, no, from the judgment, what we're arguing about here is post-judgment interest on the underlying judgment.
Right.
Right.
So that's
Judge
from the,
Davis's.
that's from the jury verdict. Is that what you mean?
From the judgment after the jury verdict.
Yes,
So-
that one.
Yes, Your Honor.
Okay.
So if I could just go back to the statutes, because we jumped ahead to purpose, and I'm arguing to you that the purpose of 93A is satisfied by the doubling and trebling of the underlying judgment. Post-judgment interest should not be included in that deterrent effect. And how do we know that? Let's not get to purpose, let's go to clear language. The post-judgment interest statute, right, the key contrast I want you to focus on is that the pre-judgment interest statute, 231, 6B and 6C, says that pre-judgment interest is always added to the damages. It says there shall be added by the clerk to the amount of damages pre-judgment interest from the date of filing to the date of entry of judgment. The contrast is with the post-judgment statute, and what I'm asking the court to do is reconcile 93A with the post-judgment interest statute, which is Chapter 231, Section 8. That does not provide that post-judgment interest is added to the judgment. To the contrary, it says, every judgment for the payment of money shall bear interest from the day of its entry, and a warrant or execution, which is a separate vehicle for collecting the post-judgment interest, shall specify the day upon which such judgment is entered. So in a nutshell, post-judgment interest is never part of the underlying judgment in the normal course. And you could only find that it was factored into 93A if there was explicit language saying so. And in 93A Section 9, the legislature pointedly didn't say you multiply the judgment plus post-judgment interest. It just said you multiply the judgment. Now, Your Honor, I'm arguing to you that post-judgment interest is never part of the judgment. Don't take it from me. Take it from the decisions of this court in CM Construction.
Now, does it matter whether the conduct which triggered 93A occurred after the judgment? I mean, in this case, there were claims that there was inappropriate conduct by your client, both during the course of prior to trial, but also after the trial in bringing an appeal with the view that there was no good reason for an appeal, because even if you prevailed on appeal, you were not going to do any better on retrial than you did at the first trial. So does that matter?
It does not, Your Honor. So it matters in the sense that post-judgment conduct can be factored into the 93A doubling or trebling. This court knows that well from Rhodes. Rhodes was a case in which the trial court found there was post-judgment conduct triggering 93A.
I remember that very well, what the trial court found, since I was the trial court.
I thought it might bring that back to mind, Your Honor.
It does,
But
it does.
in Rhodes, you allowed the
We're still
doubling.
friends.
Sorry, Your Honor.
We're still friends.
Good to see you sitting
They
together.
can't get it right all the time, I understand.
But, Your Honor, just to go back to Rhodes, Rhodes sort of illustrates the point. To be clear, this is an issue of first impression before you. We're not claiming that Rhodes decided the issue. It didn't address it. But Rhodes assumed that what you were doubling was $11 million in a judgment, and you were doubling it because of post-judgment conduct. But it pointedly did not suggest that you would also double the post-judgment interest in that case, which would have been around $700,000. In other words, you said 93A gets you to $22 million. It doesn't get you to $23.5 million. So you assumed in Rhodes that post-judgment interest wasn't included. But, Your Honor, I really would like to focus recall your attention to another set of cases by this court, the C&M Construction case and the Sheriff of Suffolk County case, because both of those cases were cases in which it really mattered, the principle that post-judgment interest does not become part of the judgment. Those were cases in which the Commonwealth was liable for contract damages. And there was a waiver of sovereign immunity as to contract claims, but there was not a waiver of sovereign immunity as to statutory interest running post-judgment or post-arbitration award. And the court held that the Commonwealth had not waived sovereign immunity on the post-judgment interest by virtue of waiving sovereign immunity on the underlying contract claim. So it's already well established that in the ordinary course, post-judgment interest is a separate statutory obligation to pay on a judgment, which has been fixed in a sum certain and a fixed date in the past. Post-judgment interest is not part of the judgment. Now, Your Honor, if you have any doubt, I think the statute is clear. 93A includes the judgment, including, Justice Lank, anything that's in the judgment. Judgment, damages from the jury, pre-judgment interest, any costs or attorney's fees that are in the judgment. Once the judgment issues from the trial court, that can be multiplied. But post-judgment interest is never part of the judgment that can be multiplied. And if you have any doubt, then I would suggest that the rule of lenity requires reading 93A Section 9 narrowly, Your Honor, because it's a punitive damages statute, as you said in Rhodes. As you said in Rhodes, multiple damages here are punitive damages. In the Commonwealth, we read penal statutes narrowly when forfeitures or punishments are involved. And unless the legislature has expressly provided for a punishment, you can't impose it. We cite the George Kalados retirement case for that principle in our brief. So we think the statute is unambiguous. Chapter 93A, Section 9, excludes post-judgment interest from the judgment to be multiplied. We think it becomes doubly clear if you read 93A Section 9 in harmony with the pre-judgment and post-judgment statutes, 231 6B and C for pre-judgment and 231 Section 8 for post-judgment, because they treat post-judgment and pre-judgment interest separately. Pre-judgment interest becomes part of the judgment, post-judgment interest does not. And you confirmed that distinction in the C&M Construction and Sheriff of Suffolk County cases in a different context, where you said sovereign immunity waivers as to claims do not include sovereign immunity waivers as to the separate statutory obligation to pay post-judgment interest.
That's a function of sovereign immunity. I mean, putting AIG in the position of the Sheriff of Suffolk County doesn't seem to me to be a good analogy.
Well, Your Honor, let's remember what's already, first of all, the principle here is simply that post-judgment interest is not part of a judgment. And what I'm arguing to you here is that 93A didn't change that. The law of the Commonwealth is that post-judgment interest is not part of the judgment. We know it from the statutes. We know it from your cases.
I think I'm having a hard time finding the complexity here. A judgment happens at a fixed period in time.
Right.
It gets entered. And then, from that point in time, you start applying post-judgment. I don't understand how the post-judgment gets into the judgment. I know I'm agreeing with you. I'm just missing the complexity of it.
Your Honor, there is no complexity. It's just that simple. And you should rule for AIG and as a result. It's just that simple, Your Honor. It's just that simple. And I just want to be clear in answer to Justice Botsford's question that we're not disserving the punitive purpose of 93A if you agree with me on that simple point. Because the trebling here, or the doubling in Rhodes, of the underlying judgment itself has punitive effect. And Chief Justice Gantz, it punishes both the pre-judgment and the post-judgment conduct. If you look at Justice Davis's opinion, he expressly notes that bringing the appeal post-judgment was part of why he found the underlying violation of 93A. So he's trebling the underlying damages partly to punish the post-judgment conduct. That's where the punishment occurs. That's where Justice Botsford's concern about the purpose of the statute is satisfied. And we can't alter the judgment law and the application of the interest laws throughout the state unless 93A tells us so. And under the rule of lenity, they didn't do so expressly.
I guess I'm really confused. I mean, are there two judgments we're talking about here? I mean, is there the first judgment and then there's the post-judgment behavior? I mean, how is it that
It's all one judgment, Your Honor.
It's all one judgment.
Correct, Your Honor.
But ordinarily, you're talking about, see, I think what I'm concerned about anyway is that in the ordinary course you're not going to be taking into account post-judgment behavior when assessing multiple damages. You're going to be taking that into account when you're first assessing the multiple damages. And then when there is no payment, post-judgment interest accrues. The question is whether or not, then I guess that should be just single or multiplied.
So, Your Honor, our position is post-judgment. Here we have the underlying tort action happens, it's done. Then there's an appeal. That happens, it's done. Then we're in 93A. What we're saying is post-judgment interest never gets factored into the multiplier, never.
No, that's what you're saying.
You get paid singly, but what gets doubled or trebled is the underlying judgment. Now, there may be other 93A cases that don't involve a
You're
judgment.
saying because the combination of your argument plus, but correct me if I'm wrong, the argument you've made so far and McAvoy would be you don't get, the plaintiffs don't get prejudgment interest either on the 176D93A, isn't that?
That's correct, Your Honor. The plaintiffs, here's what the plaintiffs will get if you rule for us today. AIG has already paid $13.8 million to the plaintiffs. We've paid $3.7 million on the underlying judgment, including prejudgment interest, post-judgment interest on the underlying judgment, and all relevant costs. We've already paid $3.7 million on the underlying case. We've already paid, prior to this appeal, $10.1 million on the 93A judgment, and, Your Honor, that means we've paid $13.8 million already. What we're asking you here to do is to send the case back with a request not to also add the $4.2 million that would be trebled post-judgment interest for the very reasons Justice Lowy expressed, plus any post-judgment interest on that. We think it's compelled by the statutes. It does not defeat the purpose of 93A, and we respectfully request a remand on that ground. Thank you, Your Honor.
How do you take into account bad faith conduct in that post-judgment time period?
Your Honor, you take it into account at the decision to double or treble. May I answer, Your Honor? I'm past my time. You take it into account in the decision whether to double or treble the underlying judgment, Your Honor. As you know, the statute says in the case of willful conduct, you must double willful damages, but it says you may go up to 3 times damages. If you look back to Justice the opinion of Justice Connolly, he's trebling partly because of the post-judgment conduct. So going from 2 times to 3 times is the place where you can take into account whether the post-judgment conduct was a violation of the statute. But where you've already had a stratospherically punitive trebling judgment that takes into account the post-judgment conduct, it would be inconsistent with the other statutes to also treble the post-judgment interest, which serves a different purpose, which is to protect the value of the money. Okay, Your Honor? If there are no further questions, thank you very much.
Thank you. Mr. Keston, good morning.
Good morning, Justices. First, my apologies. I take public transportation.
We applaud you for that, Mr. Keston.
I figured it was a point in my favor, but I came into
It's
this
not
Commonwealth.
going to affect the outcome of the case.
I understand, but that can't hurt. Secondly, it is always a pleasure for those of us that primarily do trials to get to appear before this august body. Why did they pay all this money? This is what I've been hearing. Ms. Sullivan is the 7th law firm they have hired since 1998.
Can I just, I'm just trying to get my
Yes.
numbers straight, Mr. Keston.
Anything.
The judgment, Judge Davis's judgment has been paid but for the interest? Is that what Ms. Sullivan said?
Well, she's saying that they would owe it, but of course they paid it. They paid it.
They've paid,
To cut off further interest, they finally cut a check as soon as you did not take further appellate review of that part of it.
So the only issue before us
It's the
is
interest. That's the only thing you took. And that shows me that every now and then, even you can make a mistake. Because we've been hearing about how Judge Davis considered everything in triple. Actually, no. There were 2 entities that committed bad faith at different times. That's the issue you wouldn't take. But you can change your mind. You're the SJC. There were 2 entities. The pretrial conduct was handled by 1. And the trial and post-trial conduct, which was arguably worse, was handled by 2. I've been practicing 33 years. 62% of my practice has been devoted to this case in time. He was hit by a bus in September of 1998. Liability was clear at that point. And rather than pay it, AIG and the 2 entities have hired law firms. They suborned perjury. They withheld statements. They changed the facts, and they actually successfully got a 47% contributory based on that perjury. And Judge Davis found that each entity, this is what he said, an egregious case.
Okay, but we're
Yes, sir.
we're here solely on the issue of post-judgment.
Yes, sir.
So let us put aside, let us assume that they acted very, very, very badly, and
Well, they did.
And that's been the
You don't have
finding,
to
and
assume.
they will pay. I understand that. So I guess focus on the issue of the rule of lenity. How do we get past the rule of lenity, given the fact that the statute does say the amount of the judgment, and you're asking us to read it to say the amount of the judgment, including the interest that accrued post-judgment?
Yes, sir. Because this is a unique case, and what you're asking about, what about the post-judgment interest? This is not trivial, the post-judgment. They did not, in the underlying case, they didn't make an offer, they did all this stuff until 2003. Then we got a verdict that they were very happy with. There was never even a thought of paying, and then commenced a whole new line after that judgment entered. After that judgment was put on the docket by the clerk.
Now, how much was that judgment for?
Oh,
Oh, you don't have to be exact, just roughly.
it was with 47, it was about 2.2 million,
All right, so that was the initial judgment, the
was the
underlying
judgment.
judgment.
That's the
something
tort
like that.
judgment.
That's the tort
The
judgment.
tort judgment in 2003.
Okay.
It was about 2.2 million.
After the reduction for the comparative
Yes,
negligence?
sir. About that. I mean, it's been,
Thought-
and I am getting old, so they're almost succeeding in wearing me down. But yes, that was the tort judgment. They could have paid it. Rather than pay it, and if you look at the record, they didn't even think about paying it. They engaged more lawyers,
But we
and
have
they
to-
filed a bad faith appeal, which ran its course. The difference in this case, it ran its course, so then there was a judgment after rescript.
But, Mr. Kessler, I'm sorry, what everyone's trying to say to you is this. Assume the facts are egregious. We already read the briefs and Judge Davis's decision. Just assume you are absolutely right on that, okay? We can't interpret the statute based on the facts of this case. The statute needs to be interpreted separate and distinct from the facts of this case, and that's why we're trying to get you focused on the statute. And
In this case, there was a judgment after rescript 5 years in 2008. That's the judgment that Judge Davis multiplied.
Right,
Judgment that Judge Davis did what?
Multiplied. Was
That's
the
right.
judgment after rescript, that amount.
but
Okay.
but Judge Davis's, does this case hinge on whether we agree with Judge Davis's analysis that the word judgment isn't static?
It doesn't hinge on it. It would be nice if you did, because
Well, why doesn't it hinge on it?
because I think you can also find that there's a second judgment. That in a case, and I urge you to do that, in a case where in this case, the insurer deliberately, in willful bad faith, delays payment for 5 years, takes the route all the way through further appellate reviews denied, and there's a judgment entered after rescript, that becomes the amount.
So,
Judge Davis didn't.
Okay, so you're saying somehow that the fact that there was post-judgment misconduct matters,
Yes.
and I'm trying to figure out, and that of course was part and parcel of his finding that there was a violation of 93A, both with regard to pre- and post-trial misconduct. But how does that get you where you want to go?
He found that each entity,
right, but so there was a post-appeal, this is going to Chief Justice Gant's question, was there another judgment entered on the Superior Court docket?
no, because they paid. So nothing, there was a judgment after rescript entered is what it was, not a number. And that is what they paid, and that is the number that he multiplied, because the course ran its course. What's unique about this case is the appeal ran its course. You'll never, there are no other cases, first of all, where the damages were tripled, where the conduct was this bad.
So I'm sorry to go back to this, but on the
course.
Superior Court docket, there is an entry that says judgment after rescript?
Yeah.
And that is what got paid when? I mean, it was paid after the rescript?
Yeah,
Right, so there was no further accrual of post-judgment interest at that point?
they finally paid.
Yeah, okay.
So that is the difference.
What's
And
the
that
date of that?
might be in the brief, maybe September, it was 5 years, 2008, might be September, October, November, I'm not sure. It's in my brief.
I'm trying to sort out
Okay.
the consequence of Section 9, paren 3. In most 93A cases, let's take a typical fraud case. Person engages in fraud, charged with common law fraud, damages, say, of $1 million, and then you say we're going to double or triple the damages which you caused, and it's $3 million. In the insurance context, it wasn't the insurance company which struck Mr. Anderson, but the statute says we're going to basically use that judgment as the judgment to double or treble, even though that may bear no particular resemblance to the damages caused by the insurance company with regard to its misconduct. So that puts us out of the usual contours of 93A. And so why do you say that the legislature, having imposed that punitive result, would also have meant to include post-judgment interest in that calculation?
Because if there is willful and wanton misconduct afterwards, in this case, there's both. And as I said, there's two entities. You have chosen not to hear that part of the appeal, but there's a different set of entities. It runs its course. They delay for 5 more years. They are not deterred from doing it. If you uphold, if you find for them, then basically once you commit bad faith in the underlying case, knock yourself out because the rest of the bad faith is free. You can then delay for, in this case, 5 years of the appeal in willful and wanton bad faith. You can delay it all you want. Plaintiff can't get the money, and maybe they'll die.
But didn't they get the benefit of the 3 times versus 2 times? That's the post-judgment conduct? That's why they got 3 times
No.
versus 2? That's
Well,
not why you got it?
Like I said, you didn't take that issue. He tripled because of the conduct. He never says I'm doing it because of both. He says each entity required. There's no, by Judge Davis, there is no clear ruling by him what would have happened had you said, taken it, had you said each one of them needs to be punished, decide who's 2, who's 3, then we'd know. But there's no situation where he doesn't even, the decision's not even hint of the concept that it would have been double, but then they did pass stuff, so I tripled. He found each of them separately. The judge found each entity separately liable for willful and wanton misconduct. Each one,
And
pre and post.
he tripled after a reconsideration, didn't he?
Well, as much as I admire him, he thought that the most he could give was 2.
Well, no, but ultimately he tripled.
No, he did, but that's what happened. He said the maximum penalty I'm imposing, he thought it was 2, and actually both sides agreed that it was actually 3, and Judge Davis, much to his credit, said apparently I was the only one that didn't know that. But he tripled. He said it's the most egregious thing, and he tripled. And I suggest, I mean, it could be remanded to him to say is it 1 or both, but he certainly did not say that even hint that it would have been 2, but now I'm doing 3 to account for the post. Each one he found to have committed egregious bad faith.
So in this, I'm sorry to be so slow on this, but so there's a 5-year, basically frivolous appeal period with where there were no damages paid, and it was accruing post-judgment interest, and it was on the tort judgment without the post-judgment interest that the judge trebled?
No, he
Trebled it with,
that's why we're here. He
right, he
trebled
trebled it with the post-judgment interest. So he not only trebled the damages, he not only trebled the tort judgment, he also trebled post-judgment interest that had accrued.
That's this appeal, yes. They're saying he shouldn't have done that. We're saying he did it correctly because of the judgment after rescript and because you need to punish the post-judgment conduct.
So your argument is that you would say that when you read judgment, it isn't so much the static or not static. You're saying we should be reading the word judgment as it appears in Section 9. In this case, because the Superior Court docket has a post-appeal, the Superior Court tort docket has a post-appeal entry that says judgment, you look at that and what was that number, whether it's on the docket or not, and that's what you do. That, right?
Fixed number.
Right.
Because
I mean,
on that date, we know what it is.
We know what it is because it's got post-judgment interest from 2003 to 2008.
You see, Your Honor, in the Rhodes...
Is that your...
Yes, exactly. In the Rhodes case and in Granger, those cases settled during the appeal. So they never got to a finish appeal judgment after rescript. So in a case like this, in this case, where there was willful and wanton delay for 5 years by AIG, actually by the second AIG entity, I'm not giving up that argument yet. The second AIG entity, how is that going to be deterred? And it ran its course, and there was a second judgment. It has a fixed number. We know what that number was. They paid it. And they want a freebie. It has not been deterred by Judge Davis by doing this. You know, this is not what he factored into. There's been nothing I have seen in any case I've seen which mirrors the behavior in this case. Now, I know we've got statutory interpretation, but the deterrence factor.
Okay, but we're really focusing on the statute.
But you have to, the issue is deterring insurance companies from behaving this way. That's what the statute's
But
about.
now earlier I asked about the rule of lenity, and I still haven't got your response to why the rule of lenity would not be a problem for you. Because the statute's clear enough that it includes post-judgment interest? Is that the argument?
The statute is clear. The statute says judgment. Doesn't say judgment after yes, sir. Doesn't say judgment after verdict. Doesn't say judgment after rescript.
And that seems a problem for you since it is a punitive statute and the rule of lenity would apply.
Well, that's why we're here.
Okay, but the rule of lenity, let me ask you this. Do you agree that the rule of lenity applies?
Sure.
Okay, and then how do you get past, what is your argument that the statute is clear enough to say that even with a rule of lenity, you still prevail?
Because it says judgment, and there are 2 judgments in this case, and it's the second judgment that was multiplied.
The second judgment being the...
Judgment after rescript. There is a judgment. This case finished. This case did not settle. It's always in the defendant's control. They can pay, and it's over. But in this case, rather than paying in July of 2003, in which they celebrated their victory in the contributory negligence, we know, they spent 5 years in a bad faith appeal where, if you read Judge Davis's opinion, they lied to us to the point where they said that it didn't cause any harm because we didn't believe anything they said at that point anyway. And they did that for 5 years. And if you go along with them, that'll be scot-free. Scot-free.
Okay, thank you.
Thank you. Thank you. Next time I'll be on time.